We're now going to turn our attention to another major branch of the criminal justice system, and that is the criminal courts. So this particular lecture will be divided into two broad parts. The first is to look very generally at what the function of the criminal courts are within the broader context of the criminal justice system, and then discuss how the criminal courts are organized in Canada, looking at provincial courts, superior courts, appeal courts, and the Supreme Court. And we'll also focus on Nova Scotia as a case study. The one thing to keep in mind is the criminal courts are contextualized not only by its place in the criminal justice system, but criminal courts are simply one part of the court system. So criminal courts are obviously focused on criminal matters, criminal codes and drug statute provisions, but there are also a number of other types of courts, government-run courts within provinces. So you have family courts and traffic courts and small claims courts and courts where civil suits are launched and argued. So once again, criminal courts are contextualized not only by their place in the criminal justice system, but within the larger court function that deals with a number of matters within civil society. As stated in your textbook, the criminal courts are responsible for determining the guilt or innocence of accused persons and for imposing an appropriate sentence on those who are convicted. The courts are also responsible for ensuring the rights of accused persons are protected, and this often involves monitoring the activities of various agents of the criminal justice system, including the police and systems of correction. So the criminal courts play two very important functions within the criminal justice system. The first is crime control, the broader goal of the criminal justice system, and the second is due process. In other words, the courts and judges in particular are significant to ensuring that the rights of defendants are protected and that police in particular have to adhere to certain rules and regulations and procedures in order to ensure that these rights are protected. So in other words, not only are judges and courts used for criminal trial, but police often have to go to a judge, for example, to secure a search warrant. And that lies outside of the criminal trial process, but it does indicate the other significant role that courts and judges play in the overall law enforcement process. So looking at this particular slide, if you look at the due process functions of the court, their job is to make impartial decisions, and this is obviously very important that they're not influenced by political ideologies or by the politics of government. And so the principle of judicial independence is absolutely essential to the proper functioning of the courts. This principle holds that citizens have the right to have their cases tried by tribunals that are fair, impartial, and immune from political interference. So in their role in ensuring due process, not only do they make impartial decisions based on an unbiased, independent tribunal process, but their job is to ensure that all relevant evidence is heard in the court and that all procedural rules to discover the truth in a court proceeding is followed. So in many cases, the judge in the court is the final arbiter of the criminal justice process. So they decide guilt or innocence and the extent of the punishment. And there are also many purposes the referee of the system. So there the judge in particular is to referee the adversarial system within a court process, whereas you have the defendant versus the Crown prosecutor. So the judge is primarily the referee within the trial process. Now, as far as crime control is concerned, the courts are serving the similar purpose that police or corrections or all actors play in the criminal justice system, and that is to protect society from criminals, to ensure that offenders are convicted if proven guilty and that they are punished. And they're also there to reinforce the deterrence effects of the criminal justice system through the convictions and through the sentencing and punishment of offenders. So in general, the courts play these two primary roles. They're there to contribute to the overall goals of crime control of the criminal justice system, but they're also there to ensure that due process and all the rules and procedures that police and other criminal justice actors must follow are indeed followed. So we'll now turn our attention to how courts are organized in Canada, and this will pretty much consume the remainder of this lecture. The graphic on this page shows the overall outline of Canada's court system. So as I mentioned earlier, Canada court system is not just criminal trials or criminal courts. It also includes courts that hear a vast array of other type of cases. So there's basically four branches within the overall court system. The first is the military court system. So military court-martials, discipline, and other trials with respect to the military are completely separate from the civil or criminal court system. Again, there are specific pieces of legislation that deal with court-martials and conduct within the military context. The next branch is the provincial court systems, and this includes provincial administrative tribunals, the provincial courts, which are the lowest courts, provincial territorial superior courts, and then the Court of Appeal, Provincial Court of Appeal. You also have federal courts, and these are primarily to try federal offenses. And so this will include corruption cases, for example, and it also includes drug cases. The federal government has jurisdiction over the prosecution of drug statutes, and some of these may be heard in federal courts, others may be heard in provincial courts as well. And you also finally the tax court. So in Canada, we have a court dedicated to tax matters. Now, within the context of this overall court system, it's within the provincial court system that the vast majority of criminal cases are heard, and we'll be focusing on the provincial court cases. Now, of course, overarching the whole system is the Supreme Court of Canada, which is the highest court of the land, hears appeals and decisions from lower courts from all aspects. So that includes military courts, provincial courts, federal courts, and the tax courts. So we'll talk about the Supreme Court a little later. We'll talk about their role primarily within the context of criminal courts and criminal trials. So we'll now look at the organization of courts within the provincial system. And as was mentioned earlier, there is no uniformity, real uniformity among the provinces as far as the structure or even the titles of the courts within the provincial court system is concerned. There's some uniformity, but it's difficult to generalize. So because of that, we'll focus on one province, in particular Nova Scotia. So there's basically four levels of courts dealing with criminal offenses in Nova Scotia. There's the provincial court, which is the lowest court, the Supreme Court of Nova Scotia, which has a trials division and an appeals division. There's the Provincial Court of Appeal, which hears appeals only. And then there's the Supreme Court of Canada, which of course hears cases for not just Nova Scotia, but throughout the country. So the provincial court is the lowest level of court within the Nova Scotia court system. And in most provinces, this is the same. This is true. The vast majority of criminal cases are heard in the provincial court. And the provincial court focuses exclusively on summary offenses. Historically speaking, there is some movement towards provincial courts hearing more serious indictable offenses as well, but in general, the vast majority of cases that are brought to the provincial court are for summary offenses. Now, the majority of cases are heard through judge only, and that's because, as we discussed earlier, summary offenses can only be heard by a judge. A defendant who's been charged with a summary offense does not have the option of choosing a juror. So the vast majority, if not all the cases heard in provincial court with respect to criminal offenses are heard through a judge only. In some provinces, you have divisions within a criminal court or a provincial court that will hear specific types of crimes. So in Nova Scotia, a provincial court will also hear youth criminal justice cases, including serious charges of murder. So it deals with all youth justice cases. In some provinces they'll have a special division, but in also other provinces you'll have a special court dealing with domestic violence or drug courts or mental health courts, even with Aboriginal courts. But the important thing to remember is that the provincial court is where most criminal matters are heard, and that's because the vast majority of criminal offenses are summary offenses. It's heard only by a judge, and it also will hear youth criminal justice cases. So that is criminal cases involving offenders between the ages of 12 and 17. So the next level of court that hears criminal cases in Nova Scotia is the Supreme Court of Nova Scotia. And in this province, the Supreme Court is broken into two divisions. The first is the trial division, and this is the division that will hear more serious criminal cases. In particular, it will hear cases involving indictable offenses. And so what differs the trial division from the provincial court level is not only that it hears more serious cases, but the defendant can opt for a jury. So the options are available for the defendant to have a case heard by a judge only or by a jury. Now, at the Supreme Court of Nova Scotia, there's also the Appeals Division, and this basically functions to hear appeals from the lower provincial courts. And so an appeal can be launched by a defendant or by the Crown, and regardless who launches the appeal of the decision of a provincial court judge, it's going to be heard in the Appeals Division of the Supreme Court of Nova Scotia. So all provinces have this type of court. How it's structured will differ, and the name will also differ as well. So there's in Ontario the Superior Court, and in Alberta it's the Court of Queen's Bench. You also have in some provinces called the High Court of Justice. The name will vary, but in general, most of these higher courts have a trial and an appeals division, and again function very similar to how the Supreme Court of Nova Scotia functions. So the highest court in Nova Scotia is the Provincial Court of Appeal, and this court only hears appeals. It will hear appeals from the lower court, the provincial court, and it will also hear appeals from the Supreme Court, from both the trial division and the appeals division. So its role is to review decisions made by lower courts. So in particular, the primary activities of appeal courts in provinces centers on reviewing decisions made by lower courts. So the focus is on how the law was applied to the facts of the case. In other words, the appeals court doesn't necessarily determine whether the judgment of guilt or innocent was correct. It's there to determine whether all the procedures were followed and whether the rights of the defendants were ensured in the process, and that the Charter of Rights was being respected. And it will rule on if any of these technicalities or rules were abrogated in a trial, then the case could be sent back to a trial division again. So technically, the Provincial Court of Appeals only hears decisions on technicality of cases, and mostly with respect to whether or not a particular case adhered to the Charter of Rights. Now, what also distinguishes the Court of Appeal is that instead of having just one judge preside, as in a trial court, you have three judges, and that is to ensure that that a majority decision can be made. So if you had simply had two judges, you would have a hung jury, if you can use that term. But with three judges, you would ensure that there was a majority decision, so 2 against 1, or in some cases 3 against 0. So oral arguments are made to a 3-judge panel by lawyers for both parties, the defendants and the Crown. And if a decision is rendered, when a decision is rendered by the Provincial Court of Appeal, that decision can actually be appealed all the way to Supreme Court of Canada, which is what we'll discuss next. Now, the highest court that hears criminal decisions in Nova Scotia and throughout the country is the Supreme Court of Canada, which is a federal court. This is perhaps one of the most powerful, and some would say the most powerful institution in Canadian society, especially since the introduction of the Charter of Rights and Freedoms. It's powerful because it has a final authority over all public and private law. It's responsible for interpreting the Charter of Rights, and it has the power to enforce and even cast aside legislation that has been created by the federal and provincial government. So it has the power to actually nullify legislation that has been created by the government. And we'll talk a bit about the controversy that surrounds that. But the Supreme Court of Canada, when it hears an appeal from an appeals court in Nova Scotia or for some other province, it's not there to retry a criminal case. So the Supreme Court is not a trial based on the facts presented in a lower court. Instead, it is there to determine if decisions made by a lower court are constitutional. Which often translates into the question of whether the rights of the defendant has been trampled upon. Thus, it has to make a decision, has to make its decision against the backdrop of the Charter of Rights. So, in particular, the Supreme Court and appeals court, provincial appeals court to some extent, makes decisions on the constitutionality of A, substantive law, and B, procedural matters. So, substantive law, for example, are issues such as minimum sentencing, mandatory minimum sentencing. As we talk about throughout this course, the federal Conservative government has brought in mandatory minimum sentencing for certain offenses, and provincial courts have already ruled that those mandatory minimum sentences are unjust and arbitrary and cruel punishment. So that's an example of a substantive law that the Supreme Court rules upon. Now, it also will rule on procedural matters. So, for example, it will determine the rules and regulations and extent to which police, for example, can search someone's house. And this is an actual decision made by the Supreme Court. It constantly decides on whether or not the police can search a house under certain circumstances. So if a police officer smells, for example, marijuana wafting out of the house, does that give them probable cause to enter and search the house? These are the kind of procedural laws and procedural matters that the Supreme Court determines. So the Supreme Court determines the legality and constitutionality of a whole range of criminal law, including substantive law and procedural law. And of course, it doesn't just hear about criminal law, it'll hear about all sorts of civil law and tax laws, and any law in the country can be appealed all the way to Supreme Court. And the final decision of the Supreme Court is one that all other courts must adhere to. And again, this follows the common law principle from England, and that lower courts must also always follow the decision of the higher courts. So while the decision of a provincial court of appeal will only apply to a particular province in which that decision is made, a decision by the Supreme Court will apply to the whole country. And so the Supreme Court is very powerful because governments will often have to amend or retract laws that the Supreme Court has decided upon. So again, if the Supreme Court has decided that a mandatory minimum sentence is unjust and cruel a punishment, then the federal government, the Conservative government, or whatever government's in power in Ottawa, will have to amend that law to adhere to the decision made by the Supreme Court. And so the Supreme Court and other appeals courts are extremely powerful in the country because not only do they interpret law, but in many cases they are influential in creating law because they force governments to have to amend or retract certain laws that they've created. And so the Supreme Court and Appeals Court are central to this whole debate we're having throughout the course on whether or not the Conservative government's Bill C-10 and particular provisions are constitutional, and in particular whether mandatory minimum sentences are constitutional. That hasn't gone to the Supreme Court yet, but it will, definitely will make it to the Supreme Court in future years. So Conservatives generally don't like appeals courts or Supreme Courts because they consider them too liberal and too activist. In other words, Supreme Courts and appeals courts in Canada in recent years have struck down a number of laws that have been brought into effect by the Conservative government. And as part of your readings, there's an article from Maclean's Magazine which looks at the tension between the Harper government and the Supreme Court and Appeals Court, because these courts have struck down some of the laws they brought into effect. But Supreme Court, in summary, is the most powerful court in the land. It's one of the most powerful institutions in Canadian society, and certainly not simply in the criminal justice system. It has final authority over all public and private law, and it also has the power to detract detract from government agendas by basically telling them that their laws they're enacting are not constitutional. So they have every power to force governments to rewrite or even withdraw certain laws that they've enacted. And again, the Conservative government is a good example. So by way of summary, in Nova Scotia and in most other provinces, you have the lower provincial courts, which hears the vast majority of criminal cases, because most criminal cases are summary offenses. All of these cases are heard by one judge only. The defendant cannot elect to have a jury trial. With the next level at the provincial level is a superior or Supreme Court or Court of Queen's Bench. This court in the criminal context hears serious indictable offenses, and the defendant does have the option to choose between a judge or a jury. Most provinces and territories have a provincial appeals court, and this is the highest court of the land in each province, and this reviews decisions made by lower courts, in particular superior and the provincial courts, and it will hear appeals made based on trials in superior and lower courts. And the provincial appeal courts are made up generally of a panel of 3 judges. And finally, we have the Supreme Court of Canada, which reviews certain decisions made by Provincial Court of Appeals. And both the Provincial Court of Appeals and Supreme Court listens to cases and reviews them based on the technicalities of the law and not on whether or not the guilt or innocence of the accused was justified. So in other words, these appeal courts makes decisions on the constitutionality of substantive laws and procedural laws. And all decisions made by the Supreme Court of Canada is binding for all courts in the country, and as we've discussed, can actually lead to the revision or even the repeal of certain laws created by government.